So let's go ahead and get started. Today's Get Smart Zoom class is on transactions involving powers of attorney. That is your agent, your client, whether it's a buyer or a seller, is unable to sign and needs to have someone sign for him or her or both with a power of attorney. And, like you should have gotten the primer by email about 10 minutes ago. So look in your email for that, but that's what you should see on your screen, and that's what I'm going to work from. I believe Liz is posting the primers somewhere in Elmo, and then ultimately maybe the videos, if they don't look too horrific, will get posted on the website as well. So you can always refer back to them, but if you can't find it, email Liz, Donna, Sandra, Tanya, me, and we'll get it to you. So, buying or selling with a client who needs to sign with a power of attorney really isn't all that hard, but you need to follow a few basic steps. We need to make sure the power of attorney was prepared, signed, and notarized properly. It really ought to be reviewed and vetted by everyone involved. And as you'll see as we go through the class, there are more than a few people who need to weigh in on that. And so what goes wrong is everybody just waits. It's not reviewed early enough. The problems aren't caught. You're at closing the day before closing, and it really hasn't been properly reviewed and vetted. And of course, the problem is if the client's unable to, if it's a seller to sign a deed, for example, well, then they're going to be unable to sign a new power of attorney. So it's a circular sort of problem. And with many of these kinds of things, as we've talked about in prior classes, start early. That's the real key. We can accomplish just about anything if we've got enough time to do it. So what is a power of attorney? Well, there's not some big, huge legal definition, although Virginia law does define it. And I've included that definition here. It's a writing or other record that grants authority to an agent to act in the place of the principal. If someone's got their audio, if they could mute, whether the term power of attorney is used or not. So we've got a couple of things we want to look at. One is the person giving just so we're on the same sheet of music with terms. The principal is the person who's granting the power or authority to the agent. And so the agent is the person getting the power or the authority to act for the principal. Because you guys are also called agents, it might get a little confusing. So I'm not going to use the term agent. I'm going to use the term attorney in fact. And it's the same thing. And the statute actually makes that pretty clear, whether you call it the person getting the power, the agent, the attorney in fact, or whatever. We generally use the term attorney in fact, so I'm going to use that here. So who needs to sign the power of attorney? Well, obviously the person granting the power needs to sign it. That is the principal. And again, it's got to be properly notarized, filled in, dated, signed, sealed, etc. We see powers of attorney, frankly, usually in other states, but sometimes even on a different form in Virginia, where the attorney in fact also signs the power of attorney accepting it. That's not legally required in Virginia. Not a bad idea, but it's not legally required. But the person granting the power does have to sign. And while I'm on the blanks and all of that, we'll occasionally get, everybody wants to save $1, and there's nothing wrong with that. So they'll try and draft their own based on something they've seen somewhere, or they'll go on the internet. And I got to tell you, those things are almost always wrong. They're either done wrong, they're filled out wrong. People get confused about what's to go in a given blank. And, eventually this stuff's going to make its way to me. And then I spend more time trying to help somebody fix the power of attorney than it is for me to just do the power of attorney to begin with. So there's always a little bit of that tension, but it's not the unauthorized practice of law for them to draft their own power of attorney. It would be for you, but not for them. But it's just not a good idea. All right, so who does need to approve the power of attorney? Well, the buyers, whether it's the buyer or a seller signing with a power of attorney, the buyer's settlement agent's going to have to approve it. The title insurer is going to have to approve it. And if it's for a buyer to sign, the buyer's lender, if there's one, has to review and approve it. So those are three people right off the bat, or entities that need to approve it in the process. And it takes time. And it's not unusual. In fact, a couple of our a couple of our preferred lenders want their own form used. And it's their money, and they can require that, and they do it because they've got national counsel who wants it vetted, and they don't want to have to worry about it. So sometimes you have to use their form. So we need to check on that before the buyer does a power of attorney. And the review process, I mean, we get them all the time reviewed where they're already signed. A military power of attorney is a good example of that. They did executed the power of attorney at base legal before they got shipped over. Better for us to review it before it's been signed, but just so we can correct something in advance. But again, there's no legal necessity for that. So will I personally review a power of attorney? Yes, I do. And I do that at no charge. That's just one of the things. I mean, Liz has mentioned it many times. I'm a general counsel of the company. I'm on retainer. And that's certainly included in that process. Is if you've got a client with a power of attorney and you want it reviewed, then you send it to me. And the folks at Lytle Title can also do a review. I mean, ultimately, that group's going to have to review it as well. But in terms of giving a legal opinion, I would be the one to do that. And then, of course, the others are going to have to bless it as well. So just scan the power of attorney into a PDF and send it to me. You guys know I'm pretty quick with that, and I'll get it done. I've included a checklist just because I had it done, and I've had it done for a long time for staff. And you might find that, and we'll look at it at the end, and you might find that useful. But what I don't want you to do is, you're not lawyers, no disrespect, or the underwriter or the lender or the like. So let's not rely on your review alone. If you're sitting there, I always try and be practical, Brian, and help you guys get your deals done. And so, if you're at a listing appointment and it's in the evening, and you want to get that signature on that listing agreement, and there's a power of attorney involved, I'm perfect. I think you can rely on them representing that they have the power, and you see a document, and I think that's fine. So you're okay doing that. Let's just get it to me or the appropriate folks as quickly as you can after that. In other words, you don't have to wait for Brian to approve the power of attorney when you're trying to get that listing signed on Saturday at 5 o'clock. You get it done, I'll fix it if it needs to be fixed. What is a general power of attorney? So you'll hear that a lot. So a general, as you might think, power of attorney means it's not limited in any way. It is generally applicable to pretty much everything and anything that the principal could do, the attorney, in fact, can do for the principal. Financial, real estate, personal, whatever it is, that's what we mean. But I hate to say generally a general, but that's what we mean, and that's what a general power of attorney is designed to do. So by contrast, what is a special or limited power of attorney? Well, the terms really tell you the answer. A special power of attorney, or limited, and those are really one and the same, means it's limited to a specific, usually single or sole power for a particular purpose. In our context, that's to buy or sell real estate. So we would call that a special power of attorney. It's rather than all of the things that a general power of attorney would encompass, the special power of attorney addresses the one particular thing usually a particular piece of real estate. A power of attorney can also be limited in time. And you see this most often with military-based legal powers of attorney. I don't think I've ever seen one that's not limited in time. So it'll usually be 60, 90 days, something like that. So on its terms, it's only good for a particular purpose for a particular period of time. In my specific powers of attorney that we draft, I don't include a time limit because I've seen that come back and bite folks, unfortunately. So I don't do it, and I'm not particularly worried about the impact. After all, the attorney, in fact, isn't going to buy 100 Oak Lane twice. So it's really not much of an issue. But the military has different considerations, and so they do limit those. You've just got to be careful about that time limit. And again, I've seen that on more than a few occasions be a problem. And by the way, I mean, I know I'm talking fast. We're moving through this. I've got the chat box open. So if you guys have questions, just put it in the chat box and we can talk about it. So do you use a general or special power of attorney in a real estate deal? Well, it can really be either one. A general power of attorney should be, and would be legally anyway, sufficient for either a buyer or seller, as long as that general power specifically references the required real estate powers to buy or sell. And I've never really seen, unless it was just totally messed up, a general power of attorney that did not include the power to buy and sell real estate. But that's something we look for. The problem, and we do many transactions where a seller is having someone sign for them under a general power of attorney because it was done in an estate planning context. A buyer's power of attorney really doesn't work. Legally it can, but it really doesn't work from a lender standpoint. Again, lenders, and for obvious reasons, they're loaning a lot of money. They really want the power of attorney to be specific to the transaction and to expressly and clearly authorize the buyer to sign as a borrower on the note and the deed of trust and the truth in lending and the CD and those kinds of things. And that's partially why, maybe completely why, they want to use their own forms for that purpose. So in theory, legally, a general power of attorney should work for a buyer, but as a practical matter, it does not. And so you got to be careful about that. And then, in this area, we have a lot of VA buyers and VA loans. And I think it's a matter of VA regulation that the buyer power of attorney has to reference the veteran's entitlement, the authority to use that entitlement. So there's special language for that. And when we're drafting a power of attorney for a buyer at Lytle Law, we ask whether it's a VA loan because we will include that language. So when Lytle Law is involved in is drafting the power of attorney, we always do specific powers. General powers of attorney are more an estate planning thing. So we'll do specific powers of attorney. I've been doing them for 35 years. So at this point, the form's approved by everybody, unless, again, a lender requires its own form. And we charge $150 to do that. That's lower than normal. So I discount it on transactions with Lismore agents and clients. It's $250 otherwise. Let's see, in the chat room. Rick's asking, son has mom's power of attorney. She wants to sell her house. Her son does not want her to. Well, she doesn't need her son's permission to sell her own house. That's very clear. The son can refuse to use the power of attorney to consummate the transaction, though.
She can still sign for herself, Brian.
Yeah, she can. Well, as long as she's competent, Rick.
Right. I mean, she is. She just gave it to him so he could help her with her bills and stuff like that. But she's still, she's still capable. He just does it to help Rhett, and they're just on. I try to want to get them on the same page before I move forward. But I just wanted to know the legal.
Yeah, no. I mean, just because I give my wife my power of attorney doesn't mean I need her permission to do everything for the rest of my life, including selling a house that I might own individually. So no, she does not. You just need to make sure that, she's competent. And of course, you've got to be sensitive to and this comes up a lot, where the child who's got a power of attorney or something may think mom's being taken advantage of by the evil real estate agent who just wants to make a commission. So, you just need to be sensitive to that concern. And I know you would be. So let's, always focus on that when you've got elderly clients.
Sure will. Thanks, Brian.
Yeah, sure. So can someone who is incompetent sign a power of attorney? This usually comes up with grandmas in the nursing home. We need to get a power of attorney done for her. But by the way, she hasn't the faintest idea where she is or who she is. No, you have to be competent, legally competent to sign a power of attorney. Any document for that matter, and a power of attorney is the same. So that's why it's a short answer. No, you can't do that. Is the power of attorney valid, however, if the principal becomes incompetent after the power of attorney has been signed? Yes. And, quite frankly, that's one of the reasons we do powers of attorney, particularly in an estate planning context. And so in case that ever happens, somebody can take care of it. But it's not always been the law in Virginia that happened automatically. It is the law now. It used to be that you had to have special language for a power of attorney to, and this is the language we would use, survive the principal's disability. And that's what it would say, is this power of attorney survives the principal's disability. And so what that meant is it trumped the basic law that said it doesn't continue in effect after the person becomes legally incapacitated, incompetent, Alzheimer's, that kind of thing. Now the presumption is that it does. But frankly, you'll still see power. And we used to look for that. That was the first thing I'd always look for, because powers of attorney prepared in different states may not have the same law, but the law in Virginia applies if it's being used here. So that was one of the first things I always looked for, and it was missing quite a bit.
Brian, can I ask you a question?
Yeah, sure.
So what about if the principal dies after the power of attorney is issued?
Powers of attorney are ineffective after death. Period. They end. No ifs, ands, or buts. Well, I say that there is, and you guys just need to understand the rule is somebody's dead, you can't use the power of attorney, period. Technically, the law says that as long as the attorney, in fact, has not received notice of the death and signs for the principal, then it would be valid. Now, again, the caveat there is the attorney, in fact, is unaware of the death of the principal. And that really sort of emanated from a concern over the military. You can have somebody overseas deployed in combat, and now the world's a little bit different now, but you might not know somebody had passed away for months, and in a combat World War II kind of situation. And so the law developed to say that as long as the attorney, in fact, was not aware of the death or the revocation, cancellation of the power of attorney, that it would be valid. But again, those are going to be such weird circumstances that if you're aware the person has died, the attorney, in fact, is aware of it. So I want to keep the basic answer to the question: no, powers of attorney are not effective after death. Going back to the where we were, you'll sometimes see a power of attorney noted as a durable power. And in fact, I still do this. In estate planning, I call them durable general powers of attorney. That's where the term durable comes from. It refers back to the point where we had language in the power of attorney that said it survived the principal's incompetency or legal incapacity. That is, it was durable. It survived that. Old habits die hard. And so myself, as well as frankly, most attorneys, we still call them durable powers of attorney to signify they survive it. And I still include the language, even though Virginia law has changed, just to make sure it's abundantly clear. Can you use an out-of-state or military power of attorney? Absolutely. It does have to meet the basic Virginia requirements, but base legal and the like have gotten so good at that. I really haven't ever seen that be a problem. It does have to be executed appropriately and signed and the like. There is special federal law dealing with notaries for military powers of attorney, and you guys may have seen this. Officers and overseas stations, they can notarize it, and federal law eliminates some of the particular technicalities. But the basic proposition stands, and that is it's got to meet basic Virginia law and be properly done. But that mainly means the military form has to be properly done and filled out. Does a power of attorney need magic language? That is, Brian, what are you looking for when you're reviewing? Well, there's no magic language to this, but it's got to clearly, expressly, and unequivocally grant the required real estate power. If it's a power of attorney for a seller, it needs to say in some form or fashion that the attorney, in fact, has the power to sell the real estate of the principal, execute a deed, and that kind of thing. And again, there's a lot of ways to word that. So there's no magic, bean words for it, but it's pretty clear when it's good and it's pretty clear when it's not so good. Same thing for a buyer. It's got to authorize the attorney, in fact, to purchase a property, sign the loan documents, and the like. I do want to highlight this part. Usually, the powers are incorporated by reference to a statute. So, excuse me, Virginia has passed a body of law called the Uniform Power of Attorney Act. And then there are other statutes in the Virginia Code that list powers that attorney in fact or a trustee may have. And so rather than having 5 pages of that stuff, we will incorporate those code sections by reference. And what I mean by that is you might say, I hereby grant my attorney in fact the powers set forth in Virginia Code 64.2-105, I think it is, which are hereby incorporated by reference. So you're not going to particularly know what that is, but when you see that language, that's what it's referring to. And so when I review a power of attorney or the underwriter or Lytle title, we may look that up. Now for the Virginia ones, I know them. But for example, when Lytle Law drafts a power of attorney, I'll incorporate the statutory real estate powers by reference, but then I go ahead and set them out just in case. So that's what it means when you'll see a statute incorporated by reference in a power of attorney. You really got to learn this one. Does a copy of a power of attorney work? It may work for you in the listing, and that's fine, but it will not work. It will not work to conclude the transaction. The power of attorney is going to need to be recorded, whether it's for a buyer or a seller, to evidence of record that the attorney, in fact, had the power. And clerks will not, and let me repeat, will not record a copy. For 35 years, and it's not just me, it's other lawyers, Tanner, Kelly, Moore, Frank, all of us at one point or another have been faced with a last minute situation where the client can't find the original, and we're trying to figure out how to record a copy. I mean, we've tried everything. Exhibits to the deed, that's usually the most common way. They get rejected. The clerk will not record these. All clerks, all situations, you can't record a copy. So we have to have the original. What if the original, so you got to have that original. The client may not want to part with it and say, well, no, I don't want this to get lost. And that's a real concern, when Lytle Title, for example, is taking control of grandma's only original power of attorney. And I worry about that, but we haven't lost one yet, knock on wood. But so we've got to have that original to record it. We can't do it with a copy. So they've got to hunt for it, and they've got to find it, and they've got to produce it. But what if the original has been lost? There is a mechanism by statute where if it's been recorded in a previous clerk's office, you can get that certified and then record the certified in a different jurisdiction as long as there's an affidavit. That's so hard to do in such an unusual situation. Heather managed to get it done once, but other than that once, I don't think I've ever seen that happen. And the reason is they're just usually not recorded. But those are pretty much the only circumstances. If the original's truly been lost, that child, for example, or grandchild, or whatever the situation is going to have to petition the court to be appointed as the person's conservator and guardian, but conservator for selling, and get a court order, get court permission to sell it. Really just, I did have one extremely rare situation where I got it done, but you can't, it's just not going to happen. This comes up quite a bit. Does the power of attorney apply to trust, corporations, and the like? So the typical situation here is, so you've got like an elderly parent, and as often happens, maybe the parent or parents, they have a revocable living trust for estate planning purposes. And as part of that estate planning purposes, they've given a durable general power of attorney to their daughter, and we'll use that example to help take care of things. So now they want to sell the real estate on the house, and the house is held in their revocable living trust. So the question is, can the daughter use the durable general power of attorney that dad gave her to sell property that's titled in the name of the trustee of the trust? And the general answer to that is, well, maybe. And it gets pretty tricky. The idea is, dad has given a personal general power of attorney to the daughter, but that's not the same thing as dad as trustee of dad's trust giving a power of attorney to the daughter, for the daughter to act on behalf of the trust as a trustee, if you can follow that. I mean, it's fairly technical, but it's called delegation of power. So we've got to look and see whether the trust permits that. And then we need to see whether the power of attorney was appropriately drafted to accommodate it. So you can't automatically assume that that's the case. Underwriters, we decide that on a case-by-case basis based on the language of the trust and the language of the power of attorney. It's a similar sort of analysis with a corporation. I mean, the property may be held, in a corporate name, and the president wants to give the power of attorney to the president's son because the president's, in the Caribbean living it up or something, or whatever valid reason. Well, that's even worse than a trust, because as a general rule, presidents of corporations can't delegate their authority to act in the capacity and on behalf of the corporation. And that you really, as we learned in the primer, you do that by a resolution of the board of directors. So trust maybe, corporations probably not. Those delegated authority situations, I can't give you a broad answer. It's usually no, but sometimes you can do it. As I've done on the others, I've given you a couple of sample emails. When you've got that involved, you just cut and paste, make sure it's appropriate for your deal. For example, for the buyer, there may not be a lender involved, it may be cash. So you can clip those out, you send them off early. I thought I'd just throw this in there so you guys, if you've never sat through one, just so you get a heads up. How long does an actual power of attorney closing take? Forever. If you think about the situation where somebody's signing for both the husband and wife, for example, on a buyer side closing, and you think about how thick a loan package is, oh my goodness, they just take forever. We don't charge more, probably should, but we don't. We just do what we got to do. As I've mentioned, I really went over this in the beginning. What can go wrong? It's it's not filled out correctly. It's not done right. It doesn't have the correct powers. It doesn't exist. And so you just start early. Probably every class I'll teach from here on out, one of the things I'm going to say is what can go wrong. You start too late. You don't give enough time for us to figure out what needs to be done, correct a problem, whatever. So, start early, start often, and work through it. One of the things we focus on, and this comes up quite a bit, frankly, is the powers of attorney really don't have the names correctly. There's no consistency. It's not the same name as it appears on a driver's license or a deed or something like that. We fix that, but or we work through it. Sometimes people have remarried or divorced and names have changed, and so it can get a little bit difficult, but we work through it. It's just helpful if we have some time and if it's done right at the outset. So that's one of the things at Lytle Law we try and be very careful about when we're preparing one. We want to get the names right. So how do you sign? Well, let's assume Brenda's the principal. My wife Brenda's the principal, and she's given me her power of attorney. How would I sign for her? Well, the formal signature block, like if they were sitting down and signing the contract, paper and ink, wet signing, which you guys don't do much anymore, but if it's on a contract like that, this is what it would look like. It's the 3-line deal here underneath the signature line. And although there is no legal requirement that you sign it like this, all 3 lines, really by custom and convention, that's the way it's developed, to the point where if you do it differently, somebody's going to think it's not legal. But I know my handwriting's probably hard to read, but so I've signed that to match this down here. Brenda N. Lytle by Brian D. Lytle, comma, her attorney, -N-fac. So if we're going to do it electronically, and Caitlin, thank you. Caitlin's done this in transaction desk as well. So remember, in my example, Brenda is still the seller. You don't put my name there. You put the owner, the seller's name, the principal's name. So Brenda is listed as the seller. And then for the signature line, and I've only done it this way because there's not a lot of room electronically and in transaction desk and then on the contract. The signature, the electronic signature, will appear Brenda N. Lytle, comma, by POA, rather than what I'd love to see, if you can fit it in, by Brian Lytle, her attorney in fact. So that's just shorthand for this. And I think it's legally okay because it's showing that it's being signed in a representative capacity.
Brian?
Yeah.
Brian has asked, what would initials look like on contract changes? Brenda's initials or your initials?
It's always the person who owns the property, the principal, whose name it is. It's just that I'm signing or initialing her name. So to answer that question, the initials would be B and L for Brenda N. Lytle, not BD Lytle for BDL for Brian D. Lytle. Now, how you would make that happen electronically, I suppose what we do is a couple ways. You could do B and L, comma, by POA or by BDL, but it's always the principal, the grantor's name. It's just I'm signing her name, and we're reflecting that somebody is signing her name by power of attorney. I hope that makes sense. So if we use this transaction desk example, this is what it would look like in the contract. Brenda is the seller, not me, but then I sign her name by power of attorney. And I sign her name, by the way. I don't sign my name. I don't sign Liz's name. I'm signing her name because I have her name because I have her authority in writing to do that through a power of attorney. Sheila's noting there is room to do that in Authentisign, and that's terrific. If you have the room, do the whole language, Brenda N. Lytle by Brian D. Lytle, comma, her attorney in fact, or her POA. I mean, all of that's fine. You just need to be clear that it's Brenda selling, Brian signing her name for her. And it should reflect that it's in a representative capacity. That is what you wouldn't, although it really, well, forget that. It's just, I'm signing her name and reflecting that it has been signed in a representative capacity. I hope that makes sense. The next page is that little power of attorney checklist I mentioned. And if you kind of glance at this, it'll reiterate what I've just talked about in the class. That's really all I have. I know we've gone by pretty quickly. This one ran on a bit, 35 minutes, I guess. I apologize for that. Any other questions? You can pop in on audio or chat's fine. All righty then. Well, let me just add one thing. When you guys need a power of attorney, just reach out to your processor or whatever. It's Lytle Title if the transaction's ongoing, or you're free to reach out to the law office directly. We're going to need names if it's we're going to want to get a copy of the source deed. But we work through that. You just got to let us know. Thanks everybody for tuning in. And next week's class is, what's next week's class? Liz, do you remember?
The FERPTA.
Next week's FERPTA then. That should be a pretty quick class, but that is something I want to talk to you guys about so everybody understands what's involved. And I'll see you next Thursday at 3 o'clock. Thanks, guys.
Thank you, Brian.